if you're one of those folks where your date last insured is 5, 6, 7 years ago, and you've applied once, been denied, and never appeal, or you're one of those folks who just apply over and over and over again. And this is not a blame to anyone, because in the denial, it says, oh, you can reapply or appeal.
Mm-hmm.
Oh, I'll just reapply. Mm-hmm. If you do that, then you could be, once you decide I'm going to hire a lawyer to help me, you could be legally barred from arguing you were disabled 7, 8 years ago because of all these intermittent applications you've done. Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode. I shouldn't say that. I mean, as far as I can remember, every kid's case I've ever been in, there's been a medical expert, because it just comes literally down to the listings, you know?
Yeah.
When judges and lawyers start playing doctor, it can get a little bit rough. All right. And the 10th and final thing we put down, and this is probably the most difficult disability cases to win. And I would almost put this at the top of the list as probably the number one. I don't know. There's a lot of different ones here, but above definitely fibromyalgia and chronic fatigue and Lyme. I would much rather do those cases. Anything with a DLI, date last insured, that goes into the past. So what date last insured is, let me just give the brief explanation, and if you want to touch on it more, you can, but then I'll let you talk why it's so hard. When you work and pay into Social Security, generally speaking, if you're you have to work 5 out of the last 10 years, not consecutive. And if you worked at a substantial level per quarter, you work and pay into that. Okay.
Right.
Like any insurance program, whether it be health insurance, car insurance, homeowners insurance, whatever insurance, when you stop paying your premiums, that monthly or yearly or bi-monthly or biannually bill, the clock starts ticking on how long you're insured for. So car insurance, if you stop paying, you're probably going to be uninsured in the next 30 to 60 days, right? So with Social Security, once you stop paying in at a substantial level on a consistent basis, first you got to trigger eligibility, which is the 5 years. But once that happens, and then you stop paying in, the clock starts ticking on how long you're insured for Title II Disability Insurance Benefits Program.
Mm-hmm.
You have an expiration date. That expiration date is called date last insured.
Mm-hmm.
Just like a car, even if your insurance expires, but you can prove that your car accident happened while you were insured, your insurance will cover you, right? Mm-hmm. So with date last insured, even if your insurance, like today is March, 28th, 2024, even if you prove, if your date last insured is in the past, it's called December 31st of 2023, and you're like, oh my God, we're past that now, we're, in March of 24, as long as you could prove you were disabled while you were insured, and it began there, and continued to be so, disabled, you are eligible for disability insurance benefits. For most people, when they stop working, maybe a few months go by and then they apply for disability and then their insurance is in the future, and that's easy.
Yeah.
But some people, they stopped paying in 10 years ago, and then their date last insured is 5 years ago, and now it's 5 years later. So now your date last insured is 5 years ago. Tell me why those cases are so difficult to win.
Well, you pretty much already laid it out. You're going to have to show that you were disabled before, even if it's only one day. In fact, I had a case last week one for your firm, that the person was hospitalized with congestive heart failure the month before his insurance lapsed, and this went back to 2015.
Oh, wow.
Yeah, and then he was okay for a year or so, but he didn't have insurance and he couldn't take medication, and he got sick again, and he ended up having an MI, myocardial infarction, like a year and a half after his day last insured. But I was able to pull the records out and show that his ejection fraction was low enough. In other words, the force with which his heart was pumping when he had congestive heart failure, that he actually met a limit, even just for a month before his insurance lapsed. So we won that case.
That's awesome.
Yeah. And of course, he was very deserving. It's kind of not his fault that, he had this heart disease and he had no insurance and he couldn't take medication. He just got worse and worse. He developed kidney disease, chronic kidney disease, just really kind of a mess. And it was a real shame. But, yeah.
Yeah. So that's awesome that you were able to win that. And again, as we go through this top 10 list of the toughest cases to win, we represent all of them. So we know we've been successful on all types of these cases.
Oh, yeah.
But we get prepared to argue what we know is coming.
Exactly. Yeah.
And so, but on the date last insured case, what makes it hard? The further back in time it is, the harder it is to win. Okay.
Yeah.
So if your date last insured is a year ago, not as hard if it's 3 years ago.
Right.
If your date last insured is 3 years ago, not as hard as 5 years ago or 8 years ago or 10 years ago, right? So the issue comes down to this too, is you might be disabled the entire time. You might be disabled 15 years ago and can argue that, right? But not every medical record facility keeps the records for 15 years. So then, even though you may have had treatment back then, good luck.
Yeah. Well, not only that, but cardiac disease, a lot of diseases take a long time to develop to the point where you're debilitated by them. And heart disease is an example. Back problems are an example. So, it's kind of hard to find the evidence sometimes if it's way back. And then the best you can do is get a doctor to testify, ask for a medical expert and cross-examine them about the development of how long does it take to develop 70% occlusion of your descending artery, on a heart case, as an example. How long does it take for a lumbar problem to become so critical that a person would feel unable to stand for more than an hour or so? So that's the only way. If you don't have medical records, then you want to get a medical expert, or you want to actually make that argument to the judge that, and it's common sense to some degree, that most of these things don't happen overnight. Back problems are a disease that can happen very suddenly if you've got a traumatic event. But if you don't have a traumatic event, who knows how long it took for the back to get that bad, So you just argue it.
With old date last insured, not only, are you making these arguments about how long does it take, at some point, when you're getting back like 10, 15 years, even 5 years, it's really tough, because if you don't have medical treatment, let's say your date last insured 5 years ago and you have your first medical record is last year, you have 4 years of missing medical records. As much as you want to try to argue how long does this take to develop, it's a stretch for judges to be like, oh yeah, we can go back 4 years with no.
Yeah.
Yeah. I just don't see it happening personally. I mean, you may have seen it. I think it's rare if it does happen. The other issue too, when you talk about old day last insurance, let's say 5, 6, 7, 8 years ago, you have to have a clean Social Security application record as well. And what I mean by that for our audience is, if you're one of those folks where your date last insured is 5, 6, 7 years ago, and you've applied once, been denied, and never appeal, or you're one of those folks who just apply over and over and over again. And this is not a blame to anyone, because in the denial, it says, oh, you can reapply or appeal.
Mm-hmm.
Oh, I'll just reapply. Mm-hmm. If you do that, then you could be, once you decide I'm going to hire a lawyer to help me, you could be legally barred from arguing you were disabled 7, 8 years ago because of all these intermittent applications you've done because of product.
Or going back to work. You applied and you were denied, so you went back to work for a couple of years, and then you reapplied. The other thing to bear in mind for the audience, Peter, is that we're just talking about Title II benefits. We're not talking about SSI. SSI has no time limit as to having to prove disability. And sometimes people may be eligible for Title II benefits for a period of time, but in some cases, people will be past their date last insured, but they're financially eligible at that point for SSI benefits.
Right. And to your point, there's often times where we will recommend to our clients, hey, look, if you move forward with this alleged onset date of 10 years ago, you're not going to win. But if you amend your onset date and it's going to be after your date last insured, you will likely win and probably win your SSI case because you can prove disability now. And that can be legally and financially beneficial for some folks, but it is hard to give up Title II benefits, to your point, because they've worked and paid into Social Security. And if you amend your onset date to the date after your date last insured, you're no longer, you are basically saying, I am not going to claim for the money I worked and paid into Social Security.
Exactly. And some people come into court after a period of 2 years or 3 years waiting to get their day in court. And the whole time they're thinking, oh, that's okay, because when I do go to court, I'm going to get all these back benefits. And then all of a sudden you tell them, well, and something that this is kind of the way that I try cases. And I think that it's partially responsible for a pretty good success rate. And that is, I read the room. I try to figure out what the judge is thinking. And most of these judges I know well enough to know what they're thinking or have a pretty good guess. And every judge that I know would rather make a decision easy than a decision hard. And so, if you say, well, if you persist with an old date last insured, that's going to take a long time for that judge to, edit a decision and write the instructions. And, there's always the risk of an appeal. Whereas if you make it easy for the judge and say, look, judge, I know that things got a lot worse with that car accident 2 years ago. So we're just going to amend the onset date to 2 years ago. And with the knowledge that my client is going to give up back benefits and only be eligible for SSI, for a judge, that's an easy give,
I understand. One of the audience members commented, hey, do lawyers negotiate with the judges? And it's not negotiations per se. It's just sort of lawyers and judges kind of getting on the same page about when did this disability begin. Mm-hmm. We take it serious at our firm. Amending the onset date's a big deal because we understand what people have been waiting for and giving and what they potentially could give up. And this is why hiring a good lawyer to make this analysis is, we talk about making it easy for the judge, but we're also really saying, like, this is legitimately kind of legally based off our experience.
Yeah.
Keys. and Social Security rules and regulations, reading the room, understanding what the judge is going to do here, you are going to put yourself in the best possible position to win the case if you amend it to this date, because based on our experience, this is the date we think the judge can find you disabled.
Right.
If you move forward with this date maybe 6 months earlier or 3 months earlier, we think the judge at best will give you a partially favorable, and at worst will just deny the whole thing.
Yeah.
Let me talk to the judge, see what the judge, and heck, you and I used to do this. Let me talk to the judge, see what he's thinking. And you would come at me and say, hey, I think he and I'm going to tell a joke. You would come at me and say, hey, I think he became disabled 2 months ago. And I'd be like, come on. 2 months ago? I'm like, okay, 2 days ago, Mr. Evans. I was like, wait. And then I would have a conversation about the record, and I would always be well prepared for this conversation. And I would say, Judge Hyatt's going to come at me for 2 months ago, and he's going to put it right here. And then I'm going to put it over here. And I would, and you would be open to listening to it, because having the conversation about pinpoints in the medical record about when disability began. And on more occasions than not, you and I would agree end up agreeing on some day.
Yeah.
And it's not negotiations. It's just, for folks who don't know, the average file is about 800 to 1,000 pages long. And of that, there's 600 pages of medical records on average. That's the average. We run into files that are 3,000 pages long in medical records sometimes.
Yeah.
And so, with the volume of hearings that the judges are doing, it is imperative for a lawyer to walk into that room, having read the medical records, read the file, understand the issues of the case, and being able to help the judge find things in a 1,000-page file.
Right.
I never criticized judges if you didn't know. I only criticize them if you're not even opening to looking at what I'm pointing at. You know what I mean? And most of the judges are willing to look. And you do it respectfully. Your Honor, did you see this at 7F page 23, paragraph 2? Did you see this at 14F page? And in fact, most judges, when I would say it respectfully, they would be like, "Oh man, Mr. Give me compliments for how well I knew the file."
Yeah. Well, and the bottom line here, Peter, is our interest as representatives is getting our client on disability. That's our interest. And, somebody thinking, well, I've got $20,000 in back benefits that I could get that I'm giving up. I'm sorry. What I'd like you to think about is the fact that you're only 42 and you have 36 more years of life expectancy that you're going to be on disability. Maybe. I mean, you might get cut off early, but generally that's what we're looking at is the big picture.
Right. I think also too, you get the month-to-month benefits and Medicare and things of that nature as well. So, but yeah, the older date last insureds in the past are a little bit more difficult to win. And the further in the past they are, it just becomes much more.
Yeah.
Anyway. Hey, listen, that's our top 10 list of the most difficult cases to win. You and I will get together. Let's talk about the optimistic side, the 10 most easiest cases to win next week. And we'll get that created. And we kind of have those cases down, but I appreciate it. And again, for our audience members, we're not saying these cases are impossible to win. We represent every single one of those categories of cases, whether you've been convicted of a crime, whether you are currently abusing DA&A, mental health cases, Lyme disease, fibromyalgia, chronic fatigue. We take those on at our firm. I'll link, and if you have questions about it or interested in having a representation, either, maybe Dan Hyatt will represent you himself. I enjoy
the tough cases. I really do.
Yeah.
They're a challenge.
I know you. I think every single one of our attorneys has done, almost every single one of our attorneys has done 1,000 cases or more in front of judges. And then one of our younger attorneys, they really focus on federal court work, and so they're not doing a ton of hearings. But thank you so much for your time. You gave me a ton of time today. Dan, as always, a great pleasure.
You too, Peter. Take care.
All right, you too.